This is LXBN TV, and I'm Colin O'Keefe. A small national bank recently filed a bold lawsuit claiming the entire Consumer Financial Protection Bureau and the appointment of Richard Cordray as director is unconstitutional. To discuss the lawsuit and whether it has any chance, we bring in Keith Fisher of Ballard Spahr and their outstanding CFPB Monitor. Keith, first off, what can you tell me about the basics of the lawsuit and what seems to be its fatal flaw?
Well, first of all, there are three plaintiffs. Besides the national bank you mentioned, there are two associations that are plaintiffs in the case, but neither they nor their membership seems to have any real relationship to the CFPB or what it does, such that they would get any injury from anything that the CFPB might do, any direct injury. So it's difficult to see what standing to sue they might have. Mm-hmm. The bank is a small bank. It's below the threshold for direct jurisdiction by the CFPB, but it would be subject to some CFPB actions and could claim injury. And does in the complaint assert a couple of injuries to try to get standing for itself based on those allegations. The complaint, I think, has a couple of problems. One category of problems is standing, and I'll come back to that. The other category of problems is the nature of the allegations. For instance, they say that the Bureau is unconstitutional because it is variously described in the Dodd-Frank Act that created it as an executive agency or as an independent bureau that's located within the Federal Reserve System. It's difficult to see what kind of a constitutional infirmity that allegation is addressing. It points out that there may be an inconsistency in the way the statute is worded, but that's hardly of constitutional moment. Mm-hmm. Another problem is that they say that it has authority to regulate and bring enforcement actions under a category known as UDAP, UDAAP, which is unfair, deceptive, and abusive practices, without the statute defining what unfair or deceptive or abusive might mean. But I don't see that as a constitutional problem either, because there have been similar requirements that have been enforced by federal and state agencies in the past, and sometimes that content is filled in by regulation in the future. So the fact that Congress didn't define it, I don't see as making the whole Bureau unconstitutional. So it says, they say, for instance, they allege that it has aggressive investigation and enforcement powers. And I say, okay, that's true, but where's the constitutional problem? That describes practically every federal agency, especially in the financial regulatory arena. So there are a lot of allegations like that where you read them and you say, oh, that's true, but where's the beef?
Yeah.
The second category, I think, is of problem that the lawsuit faces is, in fact, the standing question. And generally, standing requires two things. You need, first of all, injury in fact to satisfy the case or controversy requirement of Article 3 of the Constitution. And then there's a prudential standing factor. I won't get into the prudential one because we don't even get that far. Mm-hmm. It's difficult to see where this national bank in Texas alleges sufficient injury in fact. Mm-hmm. As part of their effort to do that, they make a couple of allegations. They say that they got out of the mortgage lending business in October of 2010 because there was regulatory uncertainty about the scope of the grant of authority to the Bureau. Okay, lots of regulated entities, like banks and thrifts, have for years operated under various degrees of regulatory uncertainty. And the scope of an agency's authority sometimes gets defined over time, so I don't see that as a particular injury. It's also curious that they got out of the mortgage business in October 2010, which is about 9 months before the Bureau actually came officially into existence, and well over a year before it actually got started with the appointment of Director Cordray. So I don't see that allegation is enough to confer standing. The complaint, I should also mention, challenges not only the Bureau's constitutionality, but that of the Financial Stability Oversight Council, because they say, well, they're going to be able to designate institutions that are systemically significant, and they will have a competitive advantage over smaller community banks.
I see. And assuming, so looking just at the standing and just at Cordray specifically, assuming they or someone did have the standing to bring a claim, are there aspects of Cordray's nomination that were unconstitutional?
Well, you're absolutely right. I didn't get yet to tell you that another challenge was to his appointment. Mm-hmm. And they limit their challenge in the complaint as basically relating to the fact that, okay, there was no real recess at the time. This is a problem, and it's one of several problems about the Cordray recess appointment. I can try and identify a few of those for you if you want.
Yeah, just a couple of them. I know there's been some problems. What are the specifics that stand out as being, the most problematic?
Yeah, well, one of them is, what does the word recess in the recess appointment clause mean? Does it mean, and there's a historical component to a lot of the analysis of the recess appointment clause. Originally, there wasn't enough business for Congress to stay in session very long. And they lived hundreds of miles, if not thousands of miles away, and they traveled by horse or by carriage. So when Congress recessed, they then went home, mm-hmm. and they wouldn't reconvene for another 9 or 10 months. In the meantime, things happened. People died. People died much younger and of illness much more frequently in the 18th century when the Constitution was written than they do now. And so the framers, in their wisdom, decided, well, if something happens and the president needs to appoint somebody to replace someone who has resigned or died or what have you, he can't call Congress back into session. It's going to be months before these guys can get back together again. So let's give him a recess appointment authority where that's the case. Mm-hmm. But there you're talking about a recess in between sessions of Congress, which is an intra-session recess or perhaps an intra-Congress recess, mm-hmm. and not a temporary recess of the kind that in the modern era has become much more common. So the first question you have is, okay, does the kind of recess we're talking about here, which was not an intra-session recess, count? Is that the kind of recess contemplated in the recess appointments clause? If not, the president has no authority to appoint during that period. Mm-hmm. Secondly, was there a recess at all? Because Congress kept open under a series of rules where they didn't have to actually sit every day, but they did conduct some business. And in fact, they did conduct some business during this little intercession around the holidays, late December to early January. So the president can't say, well, they did absolutely nothing. Mm-hmm. And so it wasn't a true session of Congress. Really wasn't in session. That wasn't true. Mm-hmm. No, they were in session. It was pretty quiet session. Not too much business was conducted. But so if that's the case, then there was no recess. The Justice Department, in defending the recess appointment, issued a memorandum in which they argue that the president has the authority to determine when Congress is in recess. I don't think that's true. I think the Constitution is pretty clear that it is Congress that has the authority to determine its own rules, including when it is in recess, mm-hmm. and that, in fact, both houses have to agree to be in recess. Mm-hmm. So there is that. There are a number of other arguments that I could make. A lot of them are very technical, but there are certainly sufficient arguments to provide ammunition for a challenge to the recess appointment of Mr. Cordray. And as you know, Mr. Obama also appointed 3 members of the National Labor Relations Board at the same time. Mm-hmm.
And then finally, do you see challenges to the CFPB and its director or the NLRB appointments ever gaining real legs? Is there still time for these two to pick up steam and have some power, or is it too late for that?
There have been two cases that have been filed, to my knowledge, already that have challenged the NLRB recess appointments. One of them was dismissed without reaching the question of the challenge. And another may still be ongoing, but I haven't read anything about it recently, so I'm not entirely certain what the status is. It's easier to find standing to challenge the NLRB recess appointments because the NLRB issues orders, and some people have been aggrieved by them, so they have that critical injury in fact prong of the standing analysis. The CFPB hasn't issued too many orders against anybody yet. So it's until such time as you have an institution, whether it be a bank or a non-bank financial institution, that has in fact been injured by a final agency action of the CFPB, then I don't see anybody having standing to challenge the recess appointment of Mr. Cordray. They might do that as part of a challenge to whatever the final agency action is. Let's say it's an enforcement order or something like that. One of the challenges to it might be that the agency lacks the power to have done this because they have no director. Mr. Cordray was not appointed. There is one critical difference between the NLRB and the CFPB, which I think is interesting and may interest a lot of people. The NLRB has been around since the Depression, since the New Deal era, 1933 or so, right? Whereas the CFPB is a new creation. In the NLRB's case, there have long been vacancies. And presumably there have been vacancies during a recess of Congress, so the president was able to appoint people. No one prior to Mr. Cordray had ever occupied the position of director of the Bureau of Consumer Financial Protection. So how can you say that a vacancy in that office exists?
Yeah.
I think that's an interesting constitutional argument that's available in the CFPB situation that's not available in the NLRB situation, and might very well add to the quiver of those that might someday be able to challenge the appointment.
Very interesting. Yeah, they each have their own unique circumstances where, in blunt terms, the NLRB is more apt to tick a few people off with its orders and thus face a lawsuit. But with the CFPB, we have a position with a supposed vacancy that was filled even though there wasn't even a position to start with. So it's going to be interesting to see if lawsuits pick up and how they progress. Well, once again, that was Keith Fisher of Ballard Spahr and the CFPB Monitor. For more insight on the CFPB, be sure to check out their publication. It's one of the best on our network of covering this subject, maybe the best out there. It's at cfpbmonitor.com. And for more video interviews, be sure to check us out at lxbn.lexblog.com. Thanks, Keith.
Thank you.